DUI is a serious offense in Florida and should not be taken lightly, especially if there was an accident involving either property damage or bodily injury to a third person. In addition to DUI charges, the driver may also be liable for property damage or personal injuries that were caused by the accident. If you have been charged with a DUI that has caused either property damage or bodily injury, you should contact a DUI attorney for legal advice right away. If you were under the influence of drugs or alcohol while driving a vehicle that caused serious bodily injury to another person, you may be charged with a third-degree felony. The injured party can be either a passenger in your car, a pedestrian on the street, or a person in a separate vehicle. If convicted, you may be sentenced to up to 5 years in prison and fined up to $5,000. In addition, you will have a felony conviction on your record. If the accident caused property damage, but no serious bodily injury, you may not have to face felony DUI charges. In most circumstances, a DUI with property damage is charged as a misdemeanor under Florida DUI law. However, DUIs involving property damage are still a serious offense, which should not be taken lightly. If convicted, the defendant may still be sentenced to prison and have to pay hefty fines. Further, the driver can be required to pay restitution for the property damage caused by the accident. In order to be convicted of either a DUI with property damage or DUI with serious bodily injury, the prosecutor must show that the driver actually caused the accident and was under the influence of drugs or alcohol at the time of the accident. For instance, if the driver was under the influence of drugs or alcohol but did not cause the accident, the driver may not be held liable for the bodily injury or property damage. However, it is important to remember that the driver may still face DUI penalties if convicted under these circumstances. All DUI cases are serious matters, and we carefully review every detail of the case to identify possible defenses for our clients. We aggressively scrutinize the initial stop by law enforcement, alcohol or drug testing results, witness testimony, sobriety testing procedures, and any other piece of evidence that the prosecutor may try to use against our client. Additionally, in DUI cases involving accidents, a driver may appear to be intoxicated due to the trauma and stress that the accident caused, resulting in false DUI accusations. A car accident can cause a driver to have bloodshot eyes, slurred speech, anxiety, and problems balancing or standing, all of which can significantly impact a driver's performance on field sobriety exercises given by the police officer. Our DUI lawyers will aggressively use these and any other method of defense to help our clients. If you've been arrested for DUI in Florida and would like more information on the defenses that you may have available, contact us today to schedule a free consultation.